Happy Halloween, everybody. It is Friday, October 31st. In this video, I'm going to talk about Donald Trump's tariffs. Next week, the U.S. Supreme Court is going to hear a consolidation of two cases in order to determine whether or not Donald Trump is exceeding his authority as President of the United States in imposing the two types of tariffs that he has imposed. So we are going to talk about the Appellate Court decision that consolidated these two cases and is forming the basis for what is going to happen next week in the U.S. Supreme Court. So there were two cases that were brought. In one case, 5 businesses sued over Donald Trump's tariffs. The lower court found that Donald Trump's tariffs were illegal, unconstitutional, and that he had overstepped his authority as President of the United States within certain statutory schemes. Also, that the power of the purse, taxing and things like that, belongs to the Congress, not to the President. In the second case that was consolidated, there were 12 states that sued, also in order to stop the Liberation Day tariffs, the reciprocal tariffs that Donald Trump put into place on April 2nd. The defendants in the consolidated cases are Donald Trump, Office of the President, Kristi Noem, Department of Homeland Security, Customs and Border Patrol, etc. So these cases come out of the Court of International Trade because these cases, these tariffs involve items that are imported into the United States from outside of the United States that are manufactured in other countries. That makes this case international trade, and there is a specific federal court for that. It's called the Court of International Trade. The United States Court of Appeals for the Federal Circuit heard these consolidated appeals in what's called en banc. That's spelled E-N-B-A-N-C, which means that instead of just a panel of 3 judges, all 11 of the judges who sit on the United States Court of Appeals for the Federal Circuit heard oral argument in this case and participated in drafting this opinion, a concurrence, and a dissent. There are 11 judges on this Federal Circuit. 7 judges formed the majority opinion. 4 of those 7 wrote an additional, not really a concurrence because they're part of the majority opinion, but they said, we think this decision should go further in the following ways and for the following reasons. 4 of the judges dissented. And so let's dive in. And so these tariffs came about under a statute called the International Emergency Economic Powers Act, the IEEPA. Since coming into office, Donald Trump has declared a lot of emergencies. He has done that so that he can theoretically avail himself of additional powers that are not available to the president absent an emergency. In most of these circumstances, there is a statute or statutes involved that if a president declares an emergency and if other certain requirements are met, then the president can then exercise powers that he or she normally would not have. So I'm looking at page 5 of the Appellate Circuit decision, reading from this. This case involves the extent of the president's authority under the International Emergency Economic Powers Act to regulate importing things in response to a national emergency that was declared by the president. Since taking office, Donald Trump has declared several national emergencies. In response to these declared emergencies, the president has departed from the established tariff schedules and imposed varying tariffs of unlimited duration on imports of nearly all goods from nearly every country with which the United States conducts trades. At issue in this case are 5 executive orders. And so on January 20th, Donald Trump declared the existence of a national emergency at the United States southern border with Mexico. He instituted some executive orders related to the importation of fentanyl and things that go into making fentanyl and illegal drugs that are killing Americans. So the court has labeled those, and then Donald Trump put tariffs on Canada, China, and Mexico as a result of that executive order and declaring that emergency. So he put tariffs on Canada, Mexico, China, started out at 10%, and then he changed them constantly. There was no dependability or reliability or predictability to his tariff whims. But the appellate court refers to those as the trafficking tariffs. And then there's another category that we're going to talk about called the reciprocal tariffs. So he puts the tariffs on Canada, China, and Mexico, and he did so, again, reading from the decision, in imposing these tariffs, he claimed to be acting under authority of the International Emergency Economic Powers Act, and, quote, specifically found that action under other authority to impose tariffs was inadequate to address this unusual and extraordinary threat. So he's relying specifically on this one specific statute, the International Emergency Economic Powers Act. So that's one set of tariffs on Canada, Mexico, and China. Those are the trafficking tariffs. Then on April 2nd, you guys remember Liberation Day? When he had his little chart with all the tariffs on it and all the math was wrong, and it turned out that somebody had just plugged a bad formula into ChatGPT and it spit out all these numbers that Donald Trump was relying upon in imposing tariffs on literally every single other country on the planet, including one which is just an island inhabited by penguins. Yeah, he did that. So on April 2nd, 2025, the president imposed what this opinion refers to as the reciprocal tariffs, baseline 10% tariffs on imports from nearly every country with which the United States has any significant trade relationship, with additional tariffs ranging from 11% up to 50%. And then, of course, he started shuffling all of those around and taking them up and taking them down and pausing them and unpausing them. And he was just a lunatic with these things. And he said that this was, so the emergency that he declared relative to the reciprocal tariffs is, he said, there exist trade deficits. If there are trade deficits, that's a national economic emergency, and that grants me power under the International Emergency Economic Powers Act to just do these tariffs however I want to. It's important to note that tariffs are specifically delegated to Congress in the Constitution. Yeah, and they remain that way unless Congress passes a law that delegates those powers to the office of the president. And even in that case, it's open to court interpretation, yada, yada, yada. So in imposing the reciprocal tariffs, Trump again invoked his claimed authority under the IEEPA and explained that the reciprocal tariffs addressed an unusual and extraordinary threat to the national security of the United States, posed by underlying conditions including lack of reciprocity in our bilateral trade relationships, and on and on and on. And so he puts these 10% tariffs on every country on the planet at a minimum. Then he increased the tariffs on China to 34%, then to 84%. Then I think he went up to 125%. All of that was still within the month of April. And then there were discussions. He brought them back down to 10%. Then in July, he paused the enforcement of these tariffs until August 1st. Then on July 31st, he paused them till August 7th. But then on August 7th, the tariffs went into effect. then we have these lawsuits that were filed in May. On May 28th, a 3-judge panel of the Court of International Trade granted summary judgment to the 5 business plaintiffs that we're going to talk about, saying that this is illegal. Donald Trump can't do this. He's not comporting with the language of the statute, the International Emergency Economic Powers Act. The court said that he was reading things into the statute that are not there, and thereby claiming powers that he does not normally have based on language in a statute that doesn't exist. So overall, let's pause here for a second. The lower court decision and this appellate court decision are not complicated. They're basically saying the president did X, Y, and Z under claim of authority under this particular statute. Go to the language of that statute. The language of the statute does not provide for Donald Trump to be able to do what he has been doing with the trafficking tariffs or with the reciprocal tariffs. And that's what the argument is about. What language is in that statute and the language that's in there, what does that language mean? Because Donald Trump is relying on certain language in this statute to say, well, that's the same thing as tariffs. If the president gets to do this, that means the same thing as tariffs. So I get to do tariffs all over the place like a crazy person who is off his meds. So we get these lower court decisions. The Court of Appeals for the Federal Circuit decides to consolidate these 2 cases, the one with the business plaintiffs and the one with the states as plaintiffs. And the court decided on its own motion to hear the case en banc, meaning the entire panel of all 11 judges on this federal court. And they heard oral arguments in the case and then gave us this decision here, which I think came out on August 29th. And thereafter, the Trump administration immediately appealed it to the Supreme Court on an emergency appeal. And that's the appeal that is going to be heard sometime next week. I don't know exactly what day it's going to be heard. But starting on page 12 to page 25, the court goes through a lot of very dense history of tariffs and tariff law and different acts, different laws in the history of the United States. It's really dense, it's really boring, it's important, but given that it's dense and it's boring, I'm gonna skip it. If you wanna read it, feel free. I read it and found it to be dense and boring, even though it was informative, but I'm gonna skip it here. So then we get to page 26, the legal analysis section of this court opinion. And the court lays out what they're doing, but also what they're not doing in this opinion. We are not addressing whether the president's actions, all of his tariffs, should have been taken as a matter of policy, whether or not they were good decisions. Nor are we deciding whether the International Emergency Economic Powers Act authorizes any tariffs at all. Rather, the only issue we resolve on appeal is whether the trafficking tariffs and the reciprocal tariffs imposed by these 5 executive orders are authorized by the International Emergency Economic Powers Act. We conclude they are not. So the appellate court found against Donald Trump. That's why he did the emergency appeal. So let's pause here for another second. Donald, I think it's been reported that these tariffs have brought in somewhere between $200 and $300 billion since April 2nd. If the Supreme Court agrees with the 2 lower courts and says, no, Donald Trump is not allowed to do these tariffs, the United States government is going to have to pay back all of that money to all of the people and all of the businesses who paid tariffs since April. If the entire tariff scheme is illegal and unconstitutional, the government will not get to keep the money that they brought in under that tariff scheme. They're going to have to return all of that money. Another side note, The Secretary of Commerce, Howard Butlick, I got that wrong, Howard Lutnick, is a huge proponent of these tariffs. He was formerly CEO of an investment firm in Manhattan named Cantor Fitzgerald. When he got this position, he turned over all of his business interests to his 2 adult sons. Sound familiar? Yeah. His 2 adult sons started a new business, selling tariff insurance to corporations. If a company had to spend $10 million on tariffs, Howard Lutnick's adult sons would go to that company and say, we will give you $2.5 million for the right to collect on that money if these tariffs are overturned by the court. And which these companies don't know whether these tariffs are going to be overturned. So they just spent $10 million that they never expected to see again. And here come these 2 chuds saying, we'll give you $2.5 million for those tariffs, for the right to collect on those tariffs. $2.5 million is better than nothing. If the court orders these tariffs to be reimbursed to the people who paid them, Howard Lutnick's sons will get $10 million that they paid $2.5 million for. So further commercializing and just profiting off of the executive branch by all kinds of people in this administration. Getting back to the decision, the analysis part. So the court goes through an analysis of the International Emergency Economic Powers Act, and they're discussing this statute and its language and its intent and its history, and the history in place from when it was written, from the congressional record. Notably, when drafting the IEEPA, Congress did not use the term tariff. That word does not appear anywhere in the statute, or any of its synonyms like duties or tax or taxes. None of those words appear in the very statute that the Trump administration is relying upon to say Donald Trump can do whatever he wants on tariffs. Tariffs, which are explicitly reserved as a power of the Congress in the Constitution. So the court starts out strong by saying the language you're relying on does not appear in this decision at all. In contrast, they talk about some other statutes. The use of the broad term, quote, regulate, without also separately and explicitly granting the president the authority to impose tariffs. The language of the statute also does not grant that power to Donald Trump. It does not grant him the power to impose tariffs. It does not contain the word tariffs or duty or duties or tax or taxes. None of those words appear in the statute. There is no language in the statute that says we delegate to the President of the United States the ability or the power to impose tariffs during an economic emergency that he declares. None of that is in here. And they go through some examples. It's a pretty interesting opinion if you guys want to go look it up. And they go through a discussion about the language that is in the statute, like regulate importation. And they go through an analysis that says the administration is relying on that language, regulating imports. And the court goes through an exhaustive analysis to get to the determination to say that does not include tariffs at all. It doesn't. It has nothing to do with tariffs. So 0 for 2. The statute neither mentions tariffs or any of its synonyms, nor has procedural safeguards that contain clear limits on the president's power to impose tariffs. Taken together, these and other statutes indicate that whenever Congress intends to delegate to the president the authority to impose tariffs, it does so explicitly. It uses the actual language, either by using unequivocal terms like tariff or duties, or via an overall structure which makes clear that Congress is referring to tariffs. This is no surprise, as the core congressional power to impose taxes such as tariffs is vested exclusively in the legislative branch per the Constitution. That's Congress. When Congress delegates this power in the first instance, it does so clearly and unambiguously. It did not do so in this statute, the International Emergency Economic Powers Act. Contrary to Trump's assertion, the mere authorization to regulate imports does not in and of itself imply the authority to impose tariffs. It's not in there. The power to regulate has long been understood to be distinct from the power to tax or impose tariffs. In fact, the Constitution vests these authorities, tariffs and taxation, in Congress separately. While Congress may use its taxing power in a manner that has a regulatory effect, the power to tax is not always incident to the power to regulate. They don't always go hand in hand. Let's see here. Upon declaring an emergency under the International Emergency Economic Powers Act, a president may, in relevant part, here's the language from the statute, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent or prohibit the importation or exportation of any property in which any foreign country or national thereof has an interest. Regulate must be read in the context of these verbs, none of which involve monetary actions or suggest the power to tax or impose tariffs. The government's interpretation of this statute as providing the president power to impose unlimited tariffs also runs afoul of what's called the major questions doctrine. I'm going to skip that. The statute in question, the International Emergency Economic Powers Act, was drafted into law about 50 years ago. Since then, past presidents have invoked this statute frequently, but not once has a president asserted his authority under the IEEPA to impose tariffs on imports or adjust the tariff rates thereon. For example, in the aftermath of the September 11th, 2001 terror attacks, President George W. Bush invoked the IEEPA to establish a process for designating terrorist organizations and affiliated individuals to prevent the deployment of American resources for their advantage. Under the statutes that came before the IEEPA, a president has invoked his authority to impose tariffs on only one occasion. And on that occasion, the tariffs were of very limited scope and for a very limited period of time. Donald Trump's tariffs have none of that. There are no limitations on scope. There are no limitations on time. There are no limitations on amounts. There are no limitations on how often he can change his mind and change these numbers and durations. And some of that becomes kind of important, but the executive's use of tariffs qualifies as a decision of vast economic and political significance. So the government, Trump, must, quote, point to clear congressional authorization for its interpretation of the IEEPA. For the reasons discussed above, we discern no clear congressional authorization by the IEEPA for tariffs or of the magnitude of the reciprocal tariffs and the trafficking tariffs. Reading the phrase regulate importation, to include imposing these tariffs is, quote, wafer thin on which to rest such sweeping power, quoting another case. We are unpersuaded by Trump's argument that it is particularly inappropriate to construe narrowly a delegation of power in the arena of foreign affairs and national security. While the president, of course, has independent constitutional authority in these spheres, the power of the purse belongs to Congress. Tariffs fall under the power of the purse. Absent a valid delegation by Congress, the president has no authority to impose taxes or tariffs. Given these considerations, we conclude Congress, in enacting the IEEPA, did not give the president wide-ranging authority to impose tariffs of the nature of the trafficking tariffs or the reciprocal tariffs simply by using the term regulate importation. That was not Congress's intent. But the government wants, the government's argument is that that terminology in the statute, regulate importation, regulating imports, implicitly includes tariffs and imposing tariffs and changing them all over the place like a lunatic that Donald Trump has been doing since April. They're like, no, that's what that language means. And the court is saying that's absolutely not what that language means. And they rely on some case law that came about before the IEEPA was written and saying, well, that case law existed. And so when Congress wrote the IEEPA, they were ratifying some of these former cases that have since changed. And so in conclusion, they write, even if we accept the government's argument as correct, we still must conclude that the challenged executive orders in this case exceed the authority provided by that interpretation of the IEEPA. Both the trafficking tariffs and reciprocal tariffs are unbounded in scope, amount, and duration. There's no limits, there's no framework. The government is arguing that Trump is allowed to do anything he wants to do. These tariffs apply to nearly all articles imported into the United States, and in the case of the reciprocal tariffs, apply to almost every country on the planet. They impose high rates, which are ever-changing and exceed those already in place and are not limited in duration. The trafficking and reciprocal tariffs assert an expansive authority that is beyond the express limitations of the authority delegated to the president in the statute, the IEEPA, that he is relying upon. And so concluding, the appellate court affirmed the lower court decision from the Court of International Trade. We affirm that the Court of International Trade is referred to as the CIT. We affirm the CIT's holding that the trafficking and reciprocal tariffs imposed by the challenged executive orders exceed the authority delegated to the president by the IEEPA's text. We also affirm the CIT's grant of declaratory relief that these executive orders are invalid as being contrary to law. All of Trump's executive orders on tariffs have been deemed illegal. And that is the question that is going to be before this current United States Supreme Court when they hear oral arguments next week. I gotta say, at this point, I have much more confidence that this current United States Supreme Court will completely ignore the law that is laid out in that appellate decision and the lower court decision, and will instead choose to do as they have done so many other times this year and simply say, Trump can do whatever he wants. It's fine. There's nothing to see here. This is totally fine. It doesn't matter. And on and on and on and on and on. This court has utterly beclowned itself at the throne of Donald Trump. They have changed the nature of the institution, the Supreme Court, and made that historical body, judicial body, a bootlicking supplicant of a Republican president. They did not show similar deference during Joe Biden's term. They did not show similar deference to Joe Biden at all. They are Trump bootlickers, all 6 of the conservatives on this current Supreme Court. All right, so that's your primer for oral argument next week when the Supreme Court takes up Donald Trump's trafficking tariffs against Canada, China, and Mexico, and the reciprocal Liberation Day tariffs that Donald Trump imposed on literally every single planet or every single country on the planet. So if you have any questions, please let me know in the comments, and I will try to get to those and provide you guys with additional information. Anyway, it's like a little after 1 p.m. On Halloween, Friday, October 31st. Have fun this weekend. Please be safe this weekend. See you guys soon.